It's not in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And today we have a very, very special episode because we have two lead attorneys on the UFC antitrust case. John will be interviewing Eric Cramer and Michael Dell'Angelo from Berger Montague PC. So, without any further ado, John, I'm going to hand it over to you, and you take it away, sir.
I should have worn my sports coat today. I do not feel like I'm up to snuff here. But welcome, gentlemen. You guys from one of the law firms representing the fighters in the UFC class action, the UFC antitrust case, the class action case, Lee v. Zuffa, as well as Johnson v. Zuffa. So I thought it'd be fitting, and you guys were kind enough to accept, to have you on to go over a lot of the details, because there seems to be, it should be somewhat simple, but there's a lot of confusion, I would say, out there involving the case. And so I thought it'd be very helpful if to have you guys on directly to answer some questions that are floating around. So the first question I have for either one of you two gentlemen is, who technically is a member of the Lee class? And I should, for people listening and might not, there are two class action lawsuits. The first one is the one that was class certified, Lee v. Zuffa, that was filed back in 2014. Kung Lee is the primary name plaintiff, the first. And then there's a second lawsuit that is just now getting in the courts. That is not the one that was settled. So can you describe who is technically a member of this class? What UFC fighters are a member of this class?
So I'll take that. Thanks for having us on the show, John. We're happy to talk about the case and the settlement and any of the questions that you have, because we want accurate information out there. The Lee class includes anyone who fought for the UFC from December 2010 to June. It's December 10th, 2010 to June 30th, 2017.
Okay, so that everybody that fought in this. Now, if you look at the complaint, and this is the confusion, I know some fighters call me and ask about this. If you look at the complaint, it describes a member of the Lee class as a U.S. citizen or an international fighter that fought in the United States. Is that? And I remember a while ago you had a tweet that kind of expanded that definition. So is it just those fighters that are U.S. citizens and fought in the U.S., or is it all fighters that fought in the UFC during that period?
The way our expert and we will be interpreting that as anyone who's a U.S. citizen or who fought in the United States or who fought in a fight that was broadcast in the United States. Mm-hmm. So that should be pretty much everyone who fought between December 10th, 2010 and June 30th, 2017. Okay.
I believe every UFC fight was broadcast in the United States. I'm not sure. There maybe was a couple dark matches in there. Dark is in fight business, dark matches are non-televised bouts at the beginning of a card. But that would cover at least 99 point whatever percent of the fighters. So, okay, that would answer that question. Now, that covers the class period. I guess one other question a lot of fighters have is, why does it start in 2010? And I'm sure the answer is obvious, but you go ahead.
We filed the case in December of 2014. The statute of limitations for antitrust cases is 4 years. So we went back 4 years from the date we filed the complaint, December 10, 2010. And then it goes until June 30th, 2017.
Okay. And then fighters that fought during that period and continue to fight in the UFC, they are also members of the Johnson class, because the Johnson class starts immediately after this class ends. This class ends June 30th, 2017. Johnson starts July 1st, 2017, right? And so
that's correct.
Okay,
that's
so
correct.
So you can, you're not a member of one class. You can be a member of both classes if you fought in both periods.
That's correct. And there are over 400 fighters who are members of the Lee class that would also be members of the Johnson class, which is July 1, 2017, effectively to the present.
Okay. And how many fighters do we know are in the Lee class right now? Do we estimate?
About 1,100.
Okay, 1,100. Okay. And so how much will the fighters be getting from the settlement? The settlement was $375 million. What portion gets to go to the fighters?
So The portion that goes to the fighters is everything that does not get paid to the lawyers, either in reimbursement of expenses or attorney's fees. Plus, there will be service awards for the named plaintiffs. So if you put all of that aside, the rest will go to the fighters. So that's
okay. And so in the service awards, if I remember right, Val, you were asking for $200,000 for each of the named plaintiffs.
$250,000.
Oh, $250,000. Okay, and that includes the named plaintiffs are Kong Lee, John Fitch, Javier Vasquez, Kyle Kingsbury, and Brandon Vera, and then you included Nate Quarry in that list, right? Even though technically because he was part of a separate class, the identity class that was denied class certification, you are still putting him in the group to get this bonus pay, basically.
Technically, he's not getting a service award because you have to be in the class to get a service award. He is getting a payment to release his identity rights claim, his individual identity rights claim.
Okay.
But Nate has been involved in this case from the very beginning and did a lot of work on behalf of the fighters, as did all of the other named plaintiffs that you identified.
Yeah, I mean, a lot of people have not been paying attention to the case, but if you just need to see the number of times these guys have shown up to Vegas to represent the fighters, it's, right there's a burden of effort that they've done, that they did depositions, they did all this other stuff that other fighters did not do to get this across the finish line. And so
if I could just interrupt you there, and Michael may want to add this to this, but these men did a lot of work. I mean, it wasn't just showing up to Vegas, and it wasn't just being deposed. And Michael, you might want to address some of it, because we prepared for 2 trial dates. They prepared for that, produced documents. I'll turn that over to Michael for some of the work of the named plaintiffs, so the fighters understand what these men did on behalf of the whole class. Michael, you're on. We can't hear you. While he's figuring that out, I will just say that each of the named plaintiffs did a lot of work. They produced a lot of They had to turn over all of their documents, all of their social media, all of their information. All of them had to be prepared for depositions and sit for depositions, to have the UFC's lawyers grill them for 7 hours. Michael, can we hear you now?
Can you hear me now?
Yes. Go ahead, Michael.
Yeah. So thanks, Eric. The contribution of the named plaintiffs in this case was extraordinary compared to virtually every other class action I've ever been involved in. I mean, every one of these fighters was intimately involved with putting together a very detailed complaint, and one that actually obviously survived a motion to dismiss. There was a very deep dive into their documents. But here, every one of them sat for deposition, and anybody who's, seen their depositions or the transcripts that they gave in this case, they were incredibly detailed and very well done. And they put an enormous amount of time and attention into preparing. I will tell you from my own perspective, working with them to prepare for these depositions, gave me some sense of what happens in a camp. I mean, the sort of discipline and time that they put into it was really unbelievable. But every one of these guys showed up to numerous court hearings, traveling to Las Vegas, to settlement meetings, but they were on the phone with us all the time, also helping us develop a tremendous amount of information, figuring out, the stories and the parties in this case. And this is really kind of a backstory rich case that has required these guys, every one of them, to spend, literally hundreds of hours on the phone with us, in person with us. And then as we march toward trial, the dedication that these guys had to showing up to Las Vegas, sitting with us in conference rooms day after day after day, getting prepared to testify, was like nothing I've ever seen before.
We also had 4 mediation sessions over the course of the 10 years of the case, and these guys showed up to each and every one.
Okay. And I understand, too, that they helped, like you described there, they kind of help dictate the nature of the case by describing how the nature of the business works for you guys on the outside. And I guess 10 years of labor, which it's a long time to be working on a case. So this is like, she refuses to make this professional here. So there you go. That's, I'm busy over here. The amount that's going to go to the attorneys, so that's $1.5 million set aside for those plaintiffs. The amount's going to go to the attorneys. Now, you guys you have an amount that you asked the court for. First of all, how much is for expenses? How much is for the attorney fees? And then why are the attorneys getting so much? It's going to be a question I'm sure you are asked a lot.
So in terms of expenses, this is money that the lawyers put out on behalf of the class for more than 10 years. It's about $12 million. So we spent about $12 million of our and our partners' money investing in this case mainly on experts. That's a big part of it. Also storing documents and then searching through those electronic documents that are stored. That's very expensive to use the tools and computerized search mechanisms to find the documents and use them and marshal them for depositions and other briefs, and then for the evidentiary hearing. So it was a very expensive case over a long period of time. We invested the $12 million of our own money and our partners' money in the case. So that's the expenses. In terms of attorney's fees, most people are used to contingent fee lawyers. If a corporation hires a law firm on contingency, the typical contingency is about a third. That's just typically how it is. In order for the fighters to get the best representation possible, they didn't have the money to pay lawyers out of pocket the tens of millions of dollars a year that the UFC was paying their lawyers, or even the $12 million just for the out-of-pocket expenses. So the deal is, at the beginning, the class essentially agrees to pay the lawyers on contingency. If the lawyers win, they get back their investment, plus they get paid about a third of the overall success if the judge agrees. So that's typical. Here we're asking for about 31% of the total amount, and the judge has to agree. Yep. And the judge has not yet agreed, but it's in the notice that we're asking for about 31%. It's a little over $115 million, but over 10 years, given all the investment and all of the risk, right? If we got zero, if we lost at any point, we would have gotten zero, and we would have been in the whole $12 million.
So for a lot of people listening, the $12 million is out-of-pocket expenses for other people besides the firms. That's expenses for the specialists, the econometricians, the experts, and also the 1 million documents you got from the UFC to go through. I think it was over 1 million was cited once.
And more, and it's all stored. You have to pay to store it. You have to pay to search it. That's very expensive to just have access to that information. We traveled back and forth, first of all around the country to take depositions, to Vegas. And we had private investigators. All of that has to be paid for by the lawyers, and it's a very expensive case.
And then the rest of it is you guys worked for free for 10 years, multiple firms. I don't know, the hours estimate I heard was over 100,000 hours. I don't know if that's accurate, but is that ballpark figure correct? 100,000 hours, or?
It's many hours. We haven't done the full accounting yet, which we will do, and all of that will be submitted in public, so people will get to see all of our hours and all of the time and effort we put in. Michael might want to describe some of the effort of the counsel in this case, because it's been extraordinary from the beginning.
Sure. I mean, it's been primarily led by the three firms: our firm, Berger Montague, Cohn Milstein, and the Joseph Severi law firm. But each firm has had a fairly large team of lawyers involved. I mean, there were dozens of depositions taken. But we, in the run up to the case after the motion to dismiss was decided, there were extensive negotiations with the UFC about documents, for example, that went on, for the better part of a year. Magistrate Judge Lean had the lawyers out in Las Vegas literally every month doing reports to her about the progress of discovery. Eric and you, John, mentioned that there were, million plus documents from the UFC, but there were dozens of third parties that we went, served subpoenas, fought with their lawyers, got, huge volumes of documents, and then took dozens of depositions around the country. The UFC deposed every one of our plaintiffs. There were myriad rounds of briefing throughout. We were back and forth in that court. Eric can talk a little bit about the 7-day in-person class certification hearing that we had, multiple hearings on summary judgment. And then there were, the initial settlement that we reached at the beginning of the year was 6 or so weeks out from trial. So we were heavily involved in preparing for trial, anticipating being just standing up in court for, every day for 4 weeks. And then when that settlement approval was denied, we went back to litigation, and we were sort of full-throated trial preparation, and again, running up to that again in February.
And one thing I would want, people to understand about it is we're going up against two of the best law firms in the world, Paul Weiss and Latham and Watkins. So UFC has two of the best, biggest, and most prestigious law firms in the world that we're fighting against in this case. And as a class, as a group of fighters, you're going to want on your side lawyers who are talented and skilled and experienced. And we, Michael running our law firm and Joseph Saveri running his firm and Cohen Milstein running their firm, we, for those 10 years of the case, we have to pay all of our lawyers, right? We have to pay the partners, we have to pay the lawyers, we have to pay the paralegals. And in order to be able to do that, we need to know that if we do succeed at the end of the day, there's a profit to be made. Otherwise, our partners aren't going to make the investment. So that's the trade-off. We agree to work essentially for free. We agree to make huge investments for free. Whereas, and if we lose, we get nothing back. And if we win, we get the upside, a percentage of the recovery. So our interests are completely aligned with the classes. The more money we recover on behalf of the class, the more money we can make.
Now, but still the judge has to approve this amount. So it's possible. I mean, I'm sure you guys would be happy, but I'm sure a lot of fighters would be happy. It's possible the judge lowers the amount that's awarded that you're asking for.
Yeah, it's certainly possible that everything in a class action needs to be approved by the court. So we need to go before the court, put all the information. The court obviously is well aware of the work that we did, but some courts will approve. Sometimes they reduce it a little bit. That's just the nature of our practice. I would say that given that we're going to be fighting the Johnson case, I would hope that the class members would want us to be compensated well, so we're incentivized to go forward in Johnson and fight another 5-year battle, and this time to get injunctive relief and more money on behalf of the fighters. So in order for us to have the incentive to make that investment, we need to make profits when we do succeed. The American.
I mean, yeah, I've heard in some ways that's the benefit of settling Lee and Johnson continuing is that the risk of Johnson is now less because you do not have both cases, the amount of work and effort put in without any compensation yet, any return. And so it's not as risky now going ahead with Johnson. There's not this overhanging burden of all the effort you put in.
Yeah, I think there's two things. There's that, plus we can focus now on Johnson. Before we were focused on both cases, and when you're about to go to trial, as Michael described, you're focused on trying the case. Now we can turn our focus to the second case, the Johnson case, and move that forward. And maybe we'll talk about that later.
So let's get to the part fighters probably want to hear the most about, like how much will they individually get? That's the problem. They probably, what is a fighter looking at getting for this? You have about a third going to the firms plus your expenses. I think we calculated at the hearing, it was said between 240 to 260 million should be left over for the fighters after all those expenses are deducted. So I guess a fighter listening to this, what should they expect to be their individual payment from this? Sure.
So let me give a breakdown. The average recovery of the fighters will be about $250,000. The typical recovery will be about $90,000. There are a lot of fighters who fought 1 or 2 or 3 times. Those people will get a lot less than people who fought many times. There will be 800 fighters who get more than $50,000. There will be 500 fighters who get more than $100,000. There will be 100 fighters who get more than $500,000, and 35 fighters who get more than $1 million. One other metric, and then you can follow up, that I think fighters might want to know is that we've looked at this. The average fighter in the Lee class period, 2010 to 2017, will get about 50% of the money that they earned during that period from the UFC 4 bouts. The typical fighter, median fighter, will get about 85% of the money that they earned from 2010 to 2017 fighting bouts for the UFC.
Okay. And the reason for that is because it's divided into 2 tranches, right? The 70% of the damages that are going to fighters is going to a tranche based on their total compensation they earned during that class period. And then 30% is going to be divided by the number of bouts they had during the class period. Now, you can correct me if I'm wrong, based on fighters making $556.5 million during the class period, I think was the amount that was disclosed in the case. And I can't remember, I divided by the number of total fights. The fighter, they should make, based on what the return is, somewhere between 30 and 33% of their total earnings on the one tranche, and on the other tranche, almost $14,000 per fight. Does that sound accurate?
I don't have those numbers committed to memory, but that sounds approximately correct on net. Yes.
Okay, you guys can quote me later if you want to say that. But okay, so if you're a fighter, just an example, if you're a fighter out there and you fought 10 times in the UFC and made $500,000 during your Kung Lee period, and this is only bout compensation, correct? So only your show, your win, your fight of the night bonuses, your discretionary locker room bonuses, your pay-per-view side letters, but not like the Reebok kit, not the merchandise royalty, just the bout compensation, correct? So
correct. So it's all of the bout. We took into account all of the information that we were provided in the case from the UFC about how much each fighter was paid per bout. Yep. So it doesn't include identity rights, only bout payment, but all of the bout information.
So I guess for my example, if you bought 10 times during the period, made $500,000 during the period, you would get about roughly $290,000. So over half what you earned during that class period.
These are very approximate.
Very approximate. Don't hold me on it, but I'm saying that's just a rough estimate so people get a sense of what the settlement might be. Okay, so that's important. Fighters get an idea of what they're going to get paid. The next thing is, when do they get paid is probably the next biggest priority for them.
So in a class action, and this class action will be treated like other class actions, there's a process for how long a settlement takes to get finally approved, and then for a claims process. And I'll lay out that period. So we had a hearing for preliminary approval on October 22nd, and the court entered an order preliminarily approving the settlement on October 23rd. Notice will go out to the class. All the class members get notice of the settlement and of the amount and any information that they need to know, that the court thinks they need to know about the settlement. It will go out on or before November 22nd, 2024. Fighters should get emails. There'll be social media notice. There'll be mailed notice if we don't have the emails, but we're going to do our best to make sure that every fighter in the class gets notice of the settlement. Fighters who have an objection can lodge that with the court, and the instructions for that are in the notice itself by January 21st, 2025. There will be a hearing then on February 6th, 2025 at 9:15 in the morning in Las Vegas before Judge Boulware for final approval. It's called a fairness hearing or a final approval hearing. And at that point, if there are objections, the judge will hear them. People can show up or they can be in writing. If there are no objections, the judge will have a hearing anyway. And there'll be a hearing to decide the ultimate fairness and approval of the settlement on February 6th. If the court approves it on February 6th or shortly thereafter, which we hope and expect, then there's a claims process. So now we're in February of 25, court approves it. Within 60 days, all of the fighters in the class will get a claim form. That claim form will have all the information they need to make a claim. It will include how much money we think they made during the league class period from bouts, how many bouts they fought, and we'll have the fighters and an estimate of how much money we expect them to get. And then the fighters can confirm that, or if they have problems with it, if they think the information is wrong, they can tell the claims administrator that it's wrong. So claim forms will go out sometime in April of 2025, within 60 days of final approval. And then the fighters will have about 45 days to fill out the claim form, which is basically sign it and send it in if they think it's correct, or tell the claims administrator there's an error or a problem. And so now we're in sometime in May or June of 2025. The claims administrator will have all of the information. Then we will work together with the claims administrator to come up with a list of all the fighters, how much each fighter will get. We'll submit that to the court in about June or July of 25. And then the court will approve it, we hope. And then the money can go out to the fighters. We hope to be able to do it in wire transfer if we get wire information, or checks to the fighters.
Okay. So you basically will have all the information about which fighters are eligible, how many fights they had, and so you should know if a fighter fails to make a claim, what happens to that money?
So we're going to do everything we can to make sure that every fighter who is in the class who's eligible to make a claim makes a claim, and all they have to do is basically sign the form and send it back in, and they're in. But they have to sign the form and send it in. But if they don't make a claim, then that money gets distributed to the other fighters. That's what pro rata means. So if only one fighter made a claim, that fighter would get all the money.
So you don't put ideas in any fighter's head, because one fighter is going to be like, he's going to rent a boat for all the other fighters, and that boat will never come back. But so they'll have to fill out that form, and so the money, if it's not claimed by a fighter, it doesn't like go to you guys. It doesn't. I wish it went to me, but it doesn't go to me. It doesn't go to chair. It doesn't go to an outside body. It's split amongst the other fighters, right? My understanding too is that the final date, you submit all the claims, and whoever's in that list, that's when the money's split. That's why it waits till July.
That's right. We need to know who made a claim, so that we can then say, is it 500 people who made a claim or 800 people, and then split the money among those 500 or those 800. So that's why we need all of that information before we can start sending the money out. That's why it takes a little bit longer. And also we've learned over time, since we do class actions all the time, there's often a lot of fraud in class actions. People put in claims when they don't deserve to make claims. And so we have a process in place with the claims administrator to ensure that no fraud is occurring, and that only the class members or their rightful beneficiaries, if they're no longer with us, get the money. But we have to. That's part of the reason it takes so long. We have to do it right. Everything has to be done before any dollar goes out to a class member, and we have to make sure that no fraud is occurring.
Okay, and then so fighters listening, because this point, you have a website, right, where they can start the process of getting in touch with you. UFCclassaction.com. I believe that's it. UFCclassaction.com. They can go to it. There's a link. They can fill out information to stay in touch with you guys. That way they can get a hold of you. Now, the forms they have to fill out, are these complex documents, or is it a very simple form, or is there going to be, do they need a lawyer to look over this stuff, or is it, what's the nature of, what's the work they're going to have to put in to file their claim?
They do not need a lawyer, though they're certainly welcome to have their own lawyer look at it. No problem at all. You can have anybody you want look at it, but it's supposed to be, and we want it to be, straightforward and simple. If someone have questions, they can call me, they can call Michael, they can call the claims administrator. We want to walk and talk people through it. But basically, if you get your claim form and you think it's accurate, yes, I fought 4 bouts during this period. Yes, this is how much I made during this period. All you have to do is sign it, date it, and send it in. There's no work to be done. You don't need anybody else to do it for you. Now, there are lots of companies out there that pretend to be your helper. And so they say, in order to get money from this settlement, you have to sign up with us and we'll take care of it. You do not need to do that. Those people take a lot of money on the back end for often doing very little work. Everyone will get a claim form. If you don't get a claim form, you can call us, or call the claims administrator, or email us. You will get a claim form. All you have to do is sign it and send it back. There's no work. So we want the class members to be able to get this done as easily as possible without having to pay anybody else to do it.
Yeah. And can I just emphasize that point, John, because it's a really important one for the fighters to hear, that there's a robust industry out there that will contact fighters, encouraging them to make claims, offering to assist them with the process. I mean, Eric is right. We've designed this to try to be really simple and really straightforward. And, anybody can certainly hire a lawyer to review their claim or consider, but nobody needs to hire a third party to fill out the claim form for them and pay them something to do it. A lot of these companies, try to take 25 or 33% of the claim amount, and the process is really designed for that to be unnecessary. And we're really committed to helping the fighters submit their claims and getting them submitted on time and correctly. It's a really simple process because we want to get as much of this money into the hands of the fighters and not be paying, some what we perceive to be unnecessary service that would then drain off money from the fighters.
So in some ways, if a fighter had a legitimate reason, I guess, to analyze the settlement, let's say he, thought maybe opting out might be his better option, and very rare for fighters listening, opting out means you're not part of the class action anymore. You're going to basically take the complaint yourself individually, which is very difficult, but who knows? There might be a fighter that thinks it's his better cause of action. That makes sense probably to have an attorney, but for the other fighters, and I know this is happening. I know they're getting contacted by attorneys or by management that they are not the piece they're taking. You guys are already getting paid. This is not getting paid out of your end. It's going to be paid out of the money the fighter is getting from the settlement without these people doing any additional work or improving the settlement for the fighter at all. In other words, they're just paying a sizable percentage of their damages, the settlement claim they get, without getting any extra additional benefit achieved by the attorney or the manager, whoever is going to be asking for a percentage.
That's correct. They do not need to ask a manager, a lawyer, or anyone to claim in the settlement. Now, if somebody claims that a fighter owes them money as a result of them recovering, that's between them and the person. But my recommendation to the fighter is fill out your form, call us if you have questions, sign it, get your check, and then let somebody, if they think they have a claim against you, have the money in hand, and then you could keep it or not. But I wouldn't have the money go to somebody else first. I wouldn't ask somebody else to fill out the form for you. We do not think that's necessary.
Now, a question I see raised a lot too is, you guys, the attorneys, the payment for the attorneys will go out in the spring, I think on the first or second escrow payment. Why do the attorneys get paid before the fighters?
So we will be asking to be paid. So the process is final approval hearing is in February 6, 2025. If the court enters an order on or about that date, allowing us to be paid for 10 years of work, we would take that fee from the escrow account within 30 days. So probably we'd wait 30 days in case there's an appeal. Now, we haven't talked about an appeal, but appeal is possible, and we can talk about that. If there is no appeal, we could be paid within 30 days, so sometime in March. And from our perspective, the money will be sitting in escrow, so we could wait to take that money a few months for when the fighter gets paid. But that's not going to cause the fighters to get any more or less money. Our partners and we have been waiting for 10 years to get paid, so we think it's fair that we get paid when the money becomes available, and we will do our best to make sure the fighters get paid as soon as the claims process is done and they can get paid. All of the money in escrow is earning interest right now at 4.5%, and any interest that the fighter amount earns, the fighters will get. That will be distributed to them. So to the extent there's delay, the fighters are going to be earning interest on that money during the delay.
Now, how big? I know. I've read some papers on this, that one of the tactics of paying the attorneys is to prevent what's called objector appeal or objector blackmail. So how concerned should the fighters or you guys or everybody be that will be some mounted effort to I guess sabotage the settlement so they can get a piece of it?
So what that means is if somebody objects to the settlement and the fee, they will file something with the court. And they say, we object. We think the settlement is unfair to the fighters for some reason, or unfair in that the lawyers are getting too much money for some reason, or what have you. The judge will then have the opportunity to rule. The judge can overrule the objections, and then the settlement goes forward. But if an objector whose objection was overruled, was rejected, decides to appeal to the Court of Appeals, that could delay everyone getting paid, not just the lawyers, but the class members, because nothing can go forward if there's an appeal that has a risk of overturning the entire settlement. So that is one problem, that an appeal could delay everything. Sometimes an objector will just object to the fee. And there's an industry of people out there who are trying to extract blackmail class lawyers. by simply making a frivolous objection to the fee and then holding them up and holding the lawyers up and saying, pay us a few $100,000 to go away and we'll go away. One way we've tried to deal with that in this settlement agreement is there's a provision that says if there is an objection and that objection is appealed, the lawyers, if they go to their bank and the bank says, and the bank issues a security, meaning saying that if the settlement gets overturned and if the fee has to be paid back, the bank will stand in the place in case the lawyers can't do it. So that provision would allow the lawyers to get paid if there's an objection that goes on appeal. And the reason why to do that is to try to prevent blackmailers from filing an appeal, holding up the entire settlement, holding up anyone from getting paid, including the fighters. So that's why that's there.
Okay, but if a fighter has a legitimate concern and it's a non-frivolous nature, he still can file an appeal or show up to the court and tell the judge he does not agree with it.
Exactly. If a fighter has a legitimate concern, it is their right to make an objection to the court. They can make an objection to the court, and if that objection is overturned or overruled by the court, they can appeal it. That is process that they have, that they're entitled to as a member of a class in the United States. And if someone, because it's their rights that are being adjudicated, if they do not object and the settlement is approved, they've released their rights, they've released their claim in the lead class. Nobody else can bring that claim again. So their rights are being litigated in that case. And so they have the right to object and the right to appeal if they think there's something unfair about the settlement or the fee.
Okay. Now, another complaint you probably heard when the original settlement was announced is a lot of people were disappointed with the original settlement. I think there's less disappointment with this because it splits the two classes, but there is still a lot of people that are frustrated that you guys did not take this to trial. Why didn't you take this to trial? And also, for people that might not be aware, why was injunctive relief, the idea that we're going to change the nature of the business, removed from the Lee case?
So I'll take the why did we not take this to trial first. So one thing we wanted to make sure to do is to make sure that the fighters who fought between 2010 and 2017 recovered something real and tangible from the Lee lawsuit. And if you take a case to trial, one risk is you lose. The jury decides you get nothing. Another risk is that you win, but then the other side appeals and takes 2, 3, or 4 years. So a key advantage of settlement is you get something and something significant, and you get it relatively soon. And what you saw from the declarations of the fighters is that a lot of them need this money now. They need the $50,000, the $100,000, the $200,000, the $500,000 now, and will not do them any good 5, 6 years from now. And they don't want to gamble it on a jury trial. So that's why you take a settlement. Here, I would say the $375 million settlement is extraordinary in the context of these kinds of cases. $375 million was about 40% of the damages that our expert calculated, and that is higher than most antitrust class actions ever get in settlement. So this was an extraordinary result. The other thing to know about this case, it is the first monopolization or monopsonization case on behalf of workers to get a class certified, to get past summary judgment and just before trial, and to succeed on this level. So this is an extraordinary result for the fighters, and we wanted to lock that down and lock in that victory and lock in that win, which will, as we talked about earlier, allow us to focus on the second case, the Johnson case, where the injunctive relief is, and where more damages are, right? There are over 400 fighters in Lee that will also be able to recover if we succeed in Johnson. The reason why there's no injunctive relief in Lee is because the case was filed in 2014. The UFC produced documents and data up until 2016, and we took depositions relating to facts and events from 2010 or from about 2005 to 2016. But injunctive relief, meaning business changes, are about what is happening today. we have to show that the UFC is continuing to violate the law today, and we have to point to what's going on with the contracts and the competition today. And we can't show that in a trial in 2025 based on information that we have through 2016. We would need to update all of that information. And so what happened was in Lee was all about damages, historical damages through 2017. And now Johnson, which is going to go from 2017 to the present, will focus more on what's going on now. And that way we can achieve, if we succeed, business changes and additional damages. Michael, you might want to add to that.
Sure. And that is one of the key advantages of the Johnson case, right? It gave us some comfort in settling Lee, right? Not only because you have overlap class members between Lee and Johnson, but even those who are only in the Lee class know that the fight continues and that there's another case pending before Judge Boulware where we have the opportunity not only to get damages, but to make real changes in the sport that in the combined settlement, were much more difficult to achieve.
Now, I'm probably, I don't know, it would be acceptable maybe one of you guys to come back in a few weeks or a month or something to talk about Johnson, because I don't want to get bogged down too much, because there's a lot of details in Johnson I would like to delve into, because it's a whole separate case, as we know, and just beginning. But one interesting part of Johnson is that it has these arbitration agreement class action waivers, and they're going to have standing now for Johnson to have the injunctive relief. Is it fair to say, before we get to the waivers, injunctive relief is very threatening to the UFC, and it's possible that they might settle for even a larger amount to make sure injunctive relief is not brought to bear on them? Because I'm sure you guys were aware when Bill Isaacson was talking about this case going to trial, he was warning investors or shareholders, people buying the shares, that there's no reason the shares should go down, because the true risk was injunctive relief, and that was not on the table for the Lee trial. So would injunctive relief change the nature of a possible settlement or trial for Lee because it's more threatening to the UFC? I guess that would be my first question.
So I'll take that first. The first thing I would want to say is, I think Michael and I, as lawyers for the Lee class, are much more comfortable talking about the Lee settlement, because that case is coming to a close and we're trying to get information out to the class about the nature of the settlement and how to make a claim. As you know, the Johnson case is ongoing, and so we wouldn't want to disclose either our strategy or detail about an ongoing case for reasons that you can.
No one's listening to the show. You don't have to worry. You can disclose everything you want. No one's listening.
But
so.
I would say, just to abstract from this case, just to talk in general about cases where there's injunctive relief against a company and damages. Companies that have a business practice or business practices, they tend to have that practice for a reason, because they think it makes them money, because they think it helps them control a market and overcharge consumers and underpay their workers. And they want to keep doing that, right? They'd rather write a check and keep doing what they're doing. So injunctive relief can often be an important hammer against a company. Now, we as class lawyers, we cannot ethically trade off injunctive relief and damages. They have to be done separately. So we to the extent we negotiate in another case, I'm not talking about this case, but in a case, if you're seeking both injunctive relief and damages, you need to keep them separate. I'm first going to talk about injunctive relief. These are the business changes that we're thinking about. And in settlement, then we're going to be talking about damages separately. But at this point, now talking about Johnson in particular, the judge made it very clear that he thinks it's too early to settle the case, that he wants to see certain aspects of the case litigated. And so that's that our mindset right now in Johnson is to litigate the case and move it forward and get discovery. We're just starting with discovery, meaning we're getting their documents. We'll then take their depositions, and we'll move forward with that aspect of the case, because we need to learn about what's going on in the market today. What are the business practices today, before we can really assess what changes ultimately we want to make and what are the damages to the fighters. Michael, you might want to add to that too.
I think you covered the landscape pretty well. I mean, I guess the only thing that I would add is that the threat of injunctive relief in this case is real, and it's significant, particularly for a company, that company like the UFC that has structured its business around certain practices.
Now, really quick to get back on the class action waivers and arbitration agreements, how can you talk about at all? I guess maybe you can't. How much of a hurdle they are for the Johnson case, or are they going to be a problem for you? Because technically, based on Supreme Court rulings, every fighter that signs one of those is not part of the class, and so that eliminates a large number of fighters. The potential damages in that class right there. And I guess theoretically, because if all the current fighters have it, would you have a problem with having standing to go after injunctive relief in the Johnson case?
So as to standing for injunctive relief, the court ruled in its August 2023 class certification opinion and order that in order to have standing for injunctive relief, you simply needed to have standing at the time you filed the complaint. So even if you're no longer fighting for the UFC in 2028 when the case goes to trial, as long as you had standing at the time you filed the complaint, you have standing. And that's for a good reason, right? There are lots of cases against NCAA and universities, and those cases take 3 and 4 years. Well, obviously, if somebody sues as a junior and the case takes 3 years, there would never be any opportunity to get injunctive relief because you would be graduated. So the law evaluates that and says, as long as you have the ability, you would benefit from injunctive relief when you filed. And we filed the Johnson case in 2021. That's enough. And we have a plaintiff with standing when we filed the case in 2021. And so we have that under the court's ruling. In terms of the issue of arbitration clauses and class action waivers, one thing to know is that there are a whole group of fighters who fought in the early part of the period from July 2017 through 2020 that did not sign arbitration clauses or class action waivers. So that issue wouldn't apply to them at all. As to the enforceability of those clauses, that's an issue we're going to be litigating and studying and evaluating as the case goes forward. And I don't really want to offer an opinion about what we think about those clauses at this point.
But based on the damages, let's say if the arbitration agreements don't get overturned by the court or thrown out, this case potentially the fighters that are in Johnson, they potentially could seek the type of settlement returns or whatever that the league class had. Is that a strong possibility or not for them?
We have to. I mean, one question will be for all the fighters who signed arbitration clauses and class action waivers or signed contracts that had them in there. They didn't have a choice, obviously. The question will be, are those enforceable? And if they're enforceable, that's one question about how much those claims are worth. And if they're not enforceable, it's another question about how much those claims are worth. And that will have to be litigated in the case.
Okay. But again, if you're in the league class and then you fought in Johnson, there's potential that you could see another settlement or another claim damages in the future awarded to you for Johnson. Well, that's true. Okay.
Yeah. So there's over 400 fighters who were in Lee that will also be in Johnson. And if you are in Johnson and meaning you fought July 1, 2017, and you never signed an arbitration clause or class action waiver, that issue doesn't apply to you. And if there is a settlement or judgment in Johnson, you will benefit from it.
Okay. So I guess the key information then, as we wrap up here, gentlemen, one is every fighter listening to this, when we're going to have it in the text description, both on the blog Substack and on the YouTube channel, is go to your website, right, and put in contact you guys, right? Put your name in so you guys have a means to make sure you can contact fighters. I know a lot of fighters are, it's not as fortunate to say, they're kind of paranoid about being contacted all the time. But when it's coming from you guys, it's important to answer the emails or phone calls coming from your team. Make sure you get your claim in. And that way you can get your money if you fought in the lead period. I've gotten calls from fighters that are not part of the lead period, and unfortunately, you're not in the class, unfortunately. So, but if you're in the class, contact you to get your money, and that they do not, if they want to have a lawyer or attorney look over it for their own reasons, that makes sense. But they do not need anybody to do the work for them. It's not so complex that they can't fill out the forms themselves and get the settlement themselves.
That is exactly right. And if somebody wants to reach me, I'm Eric Cramer. You can look me. It's ERICCRAMER. You can look me up on the web. My contact information, cell phone, email address, unfortunately, is all out there. So really, if you're a fighter and you have questions about your claim, call me. You can call Michael too. You might want to, Michael Dell'Angelo, also on the internet, on our website, etc.
Yeah, let me just add, John, another reason that I know some fighters are concerned about being contacted, but a reason to go to that website, update your information, reach out to us is if we have current contact information, we can make sure that you get your claim form. The fighters can decide to do with that claim form whatever they want to do, hopefully sign it and send it back and get paid, but they can choose not to. But the way that we get that claim form into their hands is if we have current contact information. We have information from the UFC. We've tried to update as much of that information as we can, and I think we've done a very good job of it. The claims administrator's job is to take, considerable efforts to get in touch with people, but there's always, in every case, some people, that move, don't have forwarding addresses, whatever, change email addresses. It can be difficult to get in touch with them. And we don't want anybody to get lost in the process.
And I think the website is UFCfighterclassaction.com. Just to be clear, you might have said UFCclassaction.com. I'm pretty sure it's UFCfighterclassaction.com. It will be in the notice. I think it's been in our press releases. And again, you could reach out to me or Michael, and we'll give you all the information you need and where to go to make a claim when that time comes. But remember, you're in the class if you do nothing. So you don't have to do anything to be in the class. But in order to make a claim early next year, about April 2025, if things go according to plan, claim forms will be sent out. And at that point, you need to sign the claim form and send it back if you want to make a claim.
Yeah, and I believe it's actually both of them. I think you have both sites. Okay. Yeah, so all right, good. Either one works.
Either one works. Good.
I go UFC class action because it's probably easier for people not to script the typing when they type out the address. But either one works. You go to it. You click on the updates for the UFC class action. On the UFC fighters class action, there's a separate about contact. Either one, make sure you get in contact with these guys so that they can get a hold of you. You get your form, get paid. I wish I could get a percentage of it. I don't, but if any fighter has pity on me, feel free to subscribe to the Hey Not the Face podcast. So is there any additional information you guys think we need to add, or is that good enough for now?
I would say that, John, you've been covering this case from the beginning, and you've put out a lot of really important information about this case. You should be commended for all the work that you've done. You get it right more often than most journalists get it right about this case. So we appreciate all the work you've done on this case to get the information out to the public. I
appreciate that. And I've noticed that my articles are on one of your websites. One of those ones, people not aware, I made it. My articles, since Bloody Elbow was destroyed, I wasn't destroyed, but whatever happened to Bloody Elbow, and all my articles were deleted. I let my articles be available to any website that wants to post them. MMA Draw, Kid Nate's, the new Bloody Elbow has them there. We have them on our Substack. And I offered them to a bunch of other websites. No one took me up, but you guys posted them on yours. So I'm more than willing to have them somewhere out there still alive so people can find them. But I guess thank you, gentlemen, for coming on the show. Good luck going forward. Again, it's UFCfighterclassaction.com or UFCclassaction.com. Go to either site, contact them. I can be reached on my Twitter handle. It's the only social media I really use is Hey Not the Face on X, Twitter. I'm also on Threads, but I don't remember what my handle is. So, and I have like 3 followers. So if you want to, you can find me there. But, otherwise, subscribe to the channel. It's free. This will be free, posted free. We have other content that you can subscribe to. Not you gentlemen, but if you want to, we'll take your money. We have no problem with that. But other people want to subscribe. We have content there. Besides that, though, everybody, on behalf of Stephanie, please stay safe.
Ow! Ow! Not the face!
Ooh, okay, the face.